Hello everyone, this is lecture 6 on the Supreme Court Rules 2013. In this video, we will discuss Order 5, which provides for business in chambers. There are 4 rules in this order. Let's begin. Rule 1. Rule 1 is power of the court, which has to be exercised by the registrar for these certain matters. The powers of the court in relation to the following matters may be exercised by the registrar, namely, application for discovery and inspection, application for delivery of interrogatories, application for substituted service or for dispensing with service of notice of the appeal on any of the respondents to the appeal under Rule 7 of Order 19. What is Order 19? Order 19 provides for appeals on certificate by High Court, and in a specific, Rule 7 of Order 19 provides for appearance by respondent. Next is fourth point, application for time to plead for production of documents and generally relating to the conduct of cause, appeal or matters save those coming under Rule 2 of this order. Rule 2 of this order means those matters which will be kept before the judge in chambers and he will exercise power of the court. Fifth is application for leave to take documents out of the custody of the court. Sixth, questions arising in connection with the payment of court fees. 7. Application for the issue of a certificate regarding any excess court fee paid under a mistake. 8th. Application for requisitioning records from the custody of any court or other authority. 9th. Application for condoning delay in paying deficit court fees. 10th. Application for condonation of delay in filing a statement of case, provided that where the registrar does not think fit to excuse the delay, he shall refer the application to the court for orders. 11. Application for appointment and for approval of a translator or interpreter. 12th. Application for withdrawal of appeal by an appellant prior to his lodging the petition of appeal. 13th. Application for production of documents outside court premises. 14th. Application for payment into court. 15th. Application for payment out of the court of money or security or interest or dividend on securities. 16th. Application for extending returnable dates of warrants. 17th. Application for refund of security deposit or part thereof, or for payment out of security deposit. 18. Application for directions regarding preparation of record. 19. Application for exemption from filing of certified copies of judgments, decrees, orders, certificates, or orders granting certificate. There's a proviso appended to it. Provided that application for exemption from filing of certified copies of judgments or orders accompanying a special leave petition shall be posted before the court along with the special leave petition. 20. Application for condonation of delay in refiling, provided the delay does not exceed 60 days from the date of notifying the defects. This is very important. It's very frequently used, this power. 21. Application for condonation of delay in filing process fee. 22. Application for extension of time for filing pleadings, provided that the registrar shall not grant more than one extension for the purpose exceeding 4 weeks. Application for cancellation of date on the written joint request of the appearing parties, provided the matter has not appeared in the final cause list on the date of filing of application. Next, office report for renewal of fixed deposit receipts and bank guarantees, subject to directions otherwise by the court. 25th, application for exemption from filing official translation. 26. Application for exemption from filing process fee or spare copies. 27. All uncontested interlocutory applications of formal nature. 28. Any matter which, in accordance with orders or directions issued by the court, is required to be dealt with by the registrar. 29th. Imposing costs on the party in default of compliance of the orders passed by the registrar. 30th and last, pre-final hearing matter to certify that the matter is ready in all respects to list the same before the court for final hearing. So basically, you will see that all these 30 applications which will be moved before the registrar, though basically they are powers of the court, but has been provided in this rule to be exercised by the registrar, because you will see these are much more procedural in nature. These are not, these orders, they won't rest as a judicial order. They are much more procedural in nature. Now, Rule 2. Rule 2 is powers of the court which has to be exercised by a single judge sitting in chambers. These applications, you will see, are much more judicial in nature. Rule 2. The powers of the court in relation to the following matters may be exercised by a single judge sitting in chambers, namely, first, application by advocate on record for leave to withdraw or for change or discharge of advocate on record. Application for leave to compromise or discontinue an appeal where permission was granted to sue as an indigent person. Third, application for striking out or adding party or for intervention in a suit, appeal, or other proceeding. Fourth, application for separate trials of cause of action. Fifth, application for separate trials to avoid embarrassment. Sixth, rejection of plaint. Seventh, application for setting down for judgment in default of written statement. Eighth, application for better statement of claim or defense. Ninth, application for particulars. 10th, application for striking out any matter in a pleading. 11th, application for amendment of pleading and for enlargement of time to amend any pleading. 12th, application to tax bills returned by the taxing officer. 13. Application for review of taxation. 14th, application for enlargement or abridgment of time except application for condonation of delay in filing SLPs. 15th, application for issue of commissions. 16th, application for assignment of security bonds. 17th, questions arising in taxation referred by the taxing officer. 18th is application for orders against clients for payment of costs. 19th, application for taxation and delivery of bill of costs and for delivery by an advocate of documents and papers. 20th, application for registration of advocates as advocates on record. So, when you will be giving your examination for advocate on record, then your application for registration will go before the judge sitting in chambers. 21. Application for leave to proceed as an indigent person. 22. Application for grant of bail where the petitioner is confined in jail for offence punishable with imprisonment up to 7 years. So remember this. 22nd application. It provides that I am an accused, I am in jail, but the offence for which I am being retained in jail, that is punishable with imprisonment up to 7 years. So will this matter, this application, whether it will go to the court? No. If it is under 7 years, then this application will go before the judge sitting in chambers. 23. Application for stay of execution of a sentence or order in criminal proceedings. 24. Application by accused persons in custody for being produced before the court at the hearing of the appeal. 25. Consent application in interlocutory matters. 26. Application by accused person for engagement of advocate under Rule 16 of Order 20. 27. Fixing the remuneration of a guardian ad litem. 28. Summons for non-prosecution, which includes the power of dismissal for non-prosecution. 29th is office report on default. 30. Application for exemption from paying court fee or extension of time for paying court fee or for furnishing, undertaking, bank guarantee or security. 31st. Application for substitution, application for condonation of delay in seeking substitution, and application involving setting aside abatement. So 3 applications are hiding in this 31. 32. Application for condonation of delay in refiling where the delay exceeds 60 days from the date of notifying the defects. 33. Application for refund of security. 34. Application for withdrawal of any appeal, petition or suit with consent of all the appearing parties or where the other side has not appeared. 35th. Application for exemption from surrendering provided that not more than one opportunity be granted for surrendering. In case of refusal and or if accused does not surrender, the matter be placed before the Honorable Judge in chambers for non-prosecution. 36. Issue of fresh summons and notices. 37th. Application of a person who is not a party to the case, appeal or matter for inspection or search or grant of copies for good cause shown. 38. Application by third parties for return of documents. 39. Application to appoint or discharge a next friend or guardian of a minor or a person of unsound mind and direct amendment of the record thereon. 40. Application for consolidation of appeals and writ petitions for purposes of hearing and preparation of records. 41. Application for amendment of pleadings with the consent of all the appearing parties or where the other side has not appeared. So this was Rule 2. See, all these 41 applications, or more than 41 applications rather, they all are work of judicial nature. That's why it has not been given to the registrar. These powers are judicial powers and thus they have to be exercised by a judge sitting in chambers. Now what is Rule 3? Well, Rule 3 is if any person is aggrieved by any order made by the registrar, within 15 days of the making of such order, he may appeal against it to the judge in chambers. I had moved an application under Rule 1 before the registrar. He passed an order. I am not satisfied. I am not feeling justice has been done. I will file an appeal against that order before the judge in chambers. Yes, there is a limitation that I will have to do that within 15 days of making of that order. Rule 4. The registrar may, and if so directed by the judge in chambers, shall at any time adjourn any matter and lay the same before the judge in chambers. And the judge in chambers may at any time adjourn any matter and lay the same before the court. So this is all for this video. Thank you for watching and please like, share and subscribe to our channel.